Council of Maharashtra. Welcome one and all to the fourth lecture of the lecture series of Bar Council of Maharashtra and Goa in its endeavor Judicial Service as a Career for Preparation for Family Court Exams 2023. On behalf of Bar Council of Maharashtra and Goa, I welcome today's resource person, Honorable Srimati Netra Kank Madam, Judge Family Court Thane, our Vice President, Vice Chairman, Honorable Dr. Uday Varunjikar Sir, and the other dignitaries. I have the honor to introduce Madam. Honorable Judge holds an LLM NET degree. She passed out LLB with a gold medal from Pune University. After attending Sanad, she practiced from year 2005 in various courts. She also worked as a visiting lecturer in MIT Pune, New Law College, Bharati Vidyapit, MMCC Pune. She passed out the family court judge examination in the year 2018 and has joined judiciary as judge of family court in the year 2019. She is presently presiding as judge at Thane Family Court. Madam has a passion for teaching and she has readily consented to guide us all for our exams. Madam's guidance on the forthcoming exams and on the topic of Hindu Marriage Act is going to benefit all of us. I request Honorable Judge Srimati Netra Kank Madam to start with her guidance lecture. Over to you, Madam.
Thank you, ma'am. Am I audible?
Yes, Madam. Yes, Madam.
Good evening, everyone. Am I audible, ma'am?
Yes, madam.
Yes, you can start.
Firstly, thank you, Bar Council of Goa, Maharashtra and Goa. Dr. Uday Varunjikar sir, Vice Chairman, Bar Council of Maharashtra and Goa. Dr. Rajendra Angule for organizing such a wonderful lecture series and inviting me and giving me a platform to deliver a lecture to the candidates who are appearing for family court exam. Now, let's start with Hindu Marriage Act 1955. Hindu Marriage Act 1955 came into existence on 18th May 1955. Yeah, the screen is visible or not?
No, madam. No. It's not.
Now?
Now it's 1 minute. Just now started. Yes.
Yes. I'll be delivering lecture with the help of PPT. So, Hindu Marriage Act 1955. Now we'll start with the application of the act. Firstly, this act is an act to amend and codify the law relating to marriages. That means this is a codifying statute firstly, and it came into existence on 18th May 1955. As per section 2 of this act is applicable to all Hindus, Buddhists, Jain or Sikhs. The important section in this important subsection is subsection 2 of section 2, which speaks about this act is not applicable to scheduled tribes. Scheduled tribes within meaning of clause 25 of article 366 of the constitution. So those scheduled tribes who are covered under article 366 clause 25 of the constitution, for those scheduled tribes people, this act is not applicable. Now let's move to the next part, that is our definition clause, and which is important one. I'll be discussing important sections from the exam point of view. Now section 3 subsection C, which is most important one, which deals with full blood as well as half blood. Full blood. What is the meaning of full blood? Full blood means two persons are said to be related to each other by full blood when they are descended from common ancestor by same wife, and half blood is a common ancestor by different wives. So full blood means when they are descended from common ancestor by same wife, and half blood means common ancestor by different wives. At the same time, the next definition, that is 3 subsection 2d, that is uterine blood, common ancestress by different husband. Two persons are related to each other by uterine blood when they are descended from common ancestress by different husband. These sections are important one. In last exam also, the questions are asked upon this question, upon these sections. Thereafter, the next, that is 3 section 3f, Sapinda relationship. Sapinda relationship, it is also important section. That is when person, that is third generation in the line of ascent through mother and fifth generation in the line of ascent through father. That is important. When two persons are related to each other, third generation in the line of ascent through mother. So through mother, it is of third generation, and through father, it is of fifth generation. Then those persons are sapindas of each other. That is called sapinda relationship. So third generation from mother and fifth generation from father. The next important definition, that is 3G, 3 subsection G, that is degrees of prohibited relationship, which includes half blood as well as uterine blood as well as full blood, illegitimate as well as legitimate child, and relationship by adoption as well as by blood. So degrees of prohibited relationship, this definition is also important from exam point of view. Thereafter, next section, that is most important one, that is conditions for a Hindu marriage, section 5. Now before discussing this section, firstly we'll have to see the section, next section. First section is section 11, section 11 of Hindu Marriage Act. Section 11 of Hindu Marriage Act speaks about void marriages. Void marriages means that marriage has no any effect, that marriage is absolutely void, it has no any value, it is ipso jure, that is from the inception, from the beginning, it is void one. Now section 11 speaks about or provides that any marriage solemnized after commencement of this act shall be null and void and may be declared by decree of nullity if it contravenes any one of the conditions specified in clauses 1, 4 and 5 of section 5. That is clauses 1, 4 and 5. I am again repeating clauses 1, 4 and 5 of section 5. That means the rest of the clauses are merely condition for a marriage, and in case of contraventions of rest of clauses, that marriage does not become void one. Merely on the contravention of conditions laid down in clauses 1, 4 and 5 of section 5, that marriage becomes void. So again, now we'll be again going on in section 5. Section 5, now conditions for a marriage. Now we are we'll be discussing the first clause, 4 clause and 5th clause firstly, and thereafter second and third clause. The first clause speaks about other spouse living. Neither party should have spouse living at the time of marriage. That is important. Neither party should have spouse living at the time of marriage. If any marriage performed and one spouse living is in existence, and in the existence of one spouse living, if another marriage has been performed, then that second marriage is absolutely void as per section 11 of Hindu Marriage Act, that I have discussed earlier, that as per section 11 Hindu Marriage Act, marriage is void one when contravention of condition laid down in clause 145 of section 5. So we are right now we are discussing section clause 1 of section 5, that is other spouse living. Neither party should have spouse living at the time of marriage. So this is condition first. Marriage becomes, now if such conditions, if such conditions does not fulfill, then the marriage becomes void, as well as it is liable for penalty under section 17 of Hindu Marriage Act. So at the same time, we'll have to read these sections together. We can say it as doctrine of pari materia, that is statute must be read or section must be read together. Now marriage becomes, so if this conditions does not fulfill, or if any party, if that party is having a spouse living and if he has performed second marriage, that second marriage is void, and that second marriage is liable, and he is liable for the penalty under section 17 of Hindu Marriage Act. So section 17 of Hindu Marriage Act provides that he is liable for penalty under section 494 and 495 of IPC. So again, means he is liable for penalty under section 494 and 495 of IPC. At the same time, wife in void marriage cannot claim maintenance under section 125 CRPC and section 18 of Hindu Marriage Adoption and Maintenance Act. She can claim interim maintenance under section 24, but she cannot claim maintenance under section 125 CRPC and under section 18 of Hindu Marriage Act, Marriage Adoption and Hindu Adoption and Maintenance Act, that is HAMA Act. So it is not, that wife is not entitled for the maintenance. Now this is first condition. Now the second condition, that is fourth one. Firstly we'll see fourth condition and fifth condition, and then we'll go further for the second condition and third condition. Now the fourth condition is degrees of prohibited relationship, and fifth condition is Sapinda relationship. As we earlier discussed, what is degrees of prohibited relationship, that has been given in section 3, and what is Sapinda relationship, that has also been provided in section 3. Now what happened if this condition does not fulfill, or if any marriage solemnized within degrees of prohibited relationship or within Sapinda relationship, then again that marriage becomes void as per section 11 of Hindu Marriage Act. And this marriage is also liable for penalty under section 18 of Hindu Marriage Act. And section 18 provides penalty, that is simple imprisonment, which may extend to 1 month, or with fine, which may extend to 1,000 rupees, or with both. So please keep these things in your mind. That is, this marriage in contravention of condition 5.1, 5.4, 5.5, then that marriage is void one as per section 11. In contravention of condition of 5 clause 1, that is other spouse living, then at that time that marriage is void one, as well as it is liable for penalty as per section 17 of Hindu Marriage Act. Section 17 of Hindu Marriage Act provides penalties, that is that persons are liable for penalty under section 494 and 495 of Hindu Marriage Act. 494 and 495 of IPC. And if degrees, if any person related with each other and they are within degrees of prohibited relationship and Sapinda relationship, then that marriage is void one and liable for penalty under section 18 of Hindu Marriage Act. And section 18 provides penalty what? That is simple imprisonment 1 month, or with fine, which may extend to 1,000 rupees. Now the next part, that is section 5 section 5 clause 2, that is unsoundness of mind. Neither party should have or incapable of giving consent due to its unsoundness of mind. Now if these condition contravenes, if any party is unsound one, if either of party is unsound one, then that marriage falls under section 12 of Hindu Marriage Act, that is voidable marriage. So that marriage is a voidable one under section 12(1)(b) of this act. So if condition laid down, that is 5(2) clause 2, unsoundness of mind due to non-performance of this condition, or if any person has contravenes this condition, then that marriage is voidable under section 12(1)(b) of this act. Now section 12(1)(b), there is difference between section 12(1)(b) and section 13, because in section 13 deals with divorce. So there are grounds of divorce under section 13, and section 13 3, section 13 subsection 1 clause 3 of act speaks about post-marital unsoundness of mind, whereas section 12(1)(b) speaks about premarital unsoundness of mind. So if either of party before marriage or unsound mind before its marriage, then that comes under section 12 of Hindu Marriage Act. So that marriage is voidable. That marriage, you cannot take divorce on that ground. If you want to take a divorce, that condition is what? There must be post-marital unsoundness of mind should be there. That means 13 is applicable only when post-marital unsoundness of mind is there, but when there is premarital unsoundness of mind, section 12 is applicable and the marriage becomes voidable. So 5 subsection 2 speaks about unsoundness of mind. Now the next, that is 5 subsection 3, that is again important. Bridegroom should has completed age of 21 years and bride should have completed age of 18 years. So bridegroom has completed age of 21 years and bride have completed age of 18 years. That is another criteria for marriage. But if this condition again violates or contravenes, then that marriage remains valid. This is important thing. That marriage remains valid. Last time same question was asked. The marriage remains valid, only liable for penalty under section 18 of Hindu Marriage Act as well as Child Marriage Restraint Act. So this marriage remains valid but liable for penalty under section 18 as well as Child Marriage Restraint Act. Under section 18 of Hindu Marriage Act and Child Marriage Restraint Act, penalty provided under section 18 of Hindu Marriage Act is rigorous imprisonment, which may extend to 2 years, or with fine, which may extend to 1 lakh rupees, or with both. So this is actual conditions for a marriage. Section 5. Due to non-compliance of conditions laid down in section 5, clause 1, 4, 5, marriage becomes void as per section 11. Due to non-compliance of condition laid down in 5 clause 1, then marriage becomes void as well as liable for penalty under section 17. That is, they are liable for punishment under section 494 and 495 of IPC. Due to non-compliance of condition laid down in clause 4 and 5 of section 5, that marriage becomes void as per section 11 of Hindu Marriage Act, as well as that marriage, those persons are liable for penalty, and that has been provided under section 18 of Hindu Marriage Act. And that penalty is simple imprisonment, which may extend to 1 month, or fine, which may extend to 1,000 rupees, or with both. Now, non-compliance of condition laid down in 5(2) clause, that is 2, 5, section 5, clause 2, that is unsoundness of mind, that marriage is voidable as per section 12 of Hindu Marriage Act. And contravention, non-compliance of condition laid down in 5(3), that is age criteria, then the marriage remains valid, only it is liable for penalty under section 18 of Hindu Marriage Act as well as Child Marriage Restraint Act. Section 18 of Hindu Marriage Act provides penalty as a rigorous imprisonment which may extend to 2 years, or with fine which may extend to 1 lakh rupees, or with both. Now we'll move to further section, that is important one, section 7. Section 7 speaks about ceremonies for Hindu marriage. Now this is most essential section. If these ceremonies does not perform, then marriage has no any value. Then apart from section 5, apart from section 11, there are 2 more sections when the marriage becomes void. Section 11 में क्या दी? Section 11 speaks about what? That is 5, 1, 4 and 5 का violation होता है, then marriage becomes void as per section 11. But section 7 speaks about ceremonies, and thereafter again there is one section, that is section 15, which speaks about when divorced person marry again. So section 7 speaks about ceremonies. Ceremonies, if Saptapadi does not perform, if Saptapadi does not takes place, then the marriage is void. But if it takes place, then doctrine of factum valid applicable here or applies. Doctrine of factum valid means once the act done, once the fact accomplished, it cannot be altered by 100 text of law or any written text of law. So once the fact done, once the act done, it cannot undo. That fact cannot be undo. Why? Because this is applicable to section 7. Why? Because once that Saptapadi takes place, and if marriage, like the next section is section 8, that is registration of marriage. Registration of marriage is compulsory, but if marriage has not been registered as per section 8 of Hindu Marriage Act, but if Saptapadi takes place, then that registration, non-registration does not make a marriage void. That marriage remains valid. Again, it is liable for merely penalty. You have to pay or fines, or you have that persons are liable for penalty. That is as per section 8, registration of marriage. In Seema versus Ashwini Kumar, it is specifically mentioned that marriage must be compulsorily registered. Marriage must be compulsorily registered. That means registration is mandatory. But doctrine at the same time, as per section 7, doctrine of factum valid is applicable. That means if Saptapadi takes place, now once the act fulfilled, once the act accomplished, no any 100 text of law can alter it. So that means once Saptapadi takes place, non-registration of marriage does not make it void. It becomes valid one, only it is liable for penalty. So the marriage, again, firstly, Saptapadi is essential ceremony. If Saptapadi does not take place, marriage is void one. But if Saptapadi takes place, then doctrine of factum valid is applicable. Though it is not registered, that marriage remains valid, only it is liable for penalty. Thereafter, next section that I'm saying, that is section 15. That is divorced person, when divorced person can remarry. Now, if divorced person remarries during the period of appeal, then that marriage is void one. So for that reason, right now I am referring this section, that void marriage, as per section 11, marriage becomes void. Even though non-compliance of Saptapadi, marriage becomes void. And even though marriage performed during appeal period, after divorce takes place and during appeal period, if marriage performed, then that marriage is void. So these are basically when the marriage is void one. These are conditions when marriage is void as per Hindu Marriage Act. Now we'll be moving on next section, that is as we have already discussed section 8, registration of marriage. Now the next section, that is section 9, restitution of conjugal rights. Everyone knows about this section, that is restitution. When either of spouse withdrawn herself or himself from the society of other without any reasonable cause, that is important. When either of spouse withdrawn herself or himself from the society of other without any reasonable cause, that other person can apply for the petition of restitution of conjugal rights. Now section 9 speaks about restitution. Explanation clause of this section is also important. That is, it speaks about when question arises as to whether there has been reasonable excuse for withdrawn from the society, the burden of proving reasonable excuse shall be on the person who has withdrawn from the society. In last question exam, same question was asked, that is, upon whom the burden lies. If there is a question as to reasonable excuse, then upon whom the burden of proof lies? The burden of proof lies on the person who has withdrawn from the society. Initially, the burden lies upon the petitioner. If a person has filed a petition for restitution of conjugal right, initial burden lies upon him to prove that other party has withdrew himself or herself without any reasonable cause. But if other party is showing reasonable cause, then burden lies upon other party to show that he had a reasonable cause to withdraw himself or herself from the society. So meanwhile, during the trial, that burden shifts on other party. So burden of proof initially lies on petitioner to prove that other person has withdrawn himself or herself from the society. Now other person is taking defense that I had reasonable excuse, for that reason I had withdrew myself from the society. So now that burden shifts, that onus shifts upon the respondent to show that he had a reasonable excuse to withdraw herself or himself from the society. Someone has asked a question about doctrine of factum valid. Yeah, ma'am. Hello. Hello.
हा मॅडम, तुम्ही चालू ठेवा मॅडम. ते
नाही, कोणीतरी प्रश्न विचारलाय, मी नंतर सांगू का ते
हो,
काय
नंतर सांगा मॅडम, तुम्ही शेवटी क्वेश्चन आन्सर.
ओके ओके फाईन. So now this burden of proof, initially burden of proof lies on petitioner, and later on that burden shifts on the respondent to prove that he had a reasonable cause to withdraw herself or himself from the society. Now this section, at the same time, section 22 of Special Marriage Act deals with restitution of conjugal right. So section 9 of Hindu Marriage Act deals with restitution of conjugal right, whereas section 22 of Special Marriage Act deals with restitution of conjugal right. Okay, now next section, we'll be moving towards the next section. That is, I have already covered this section, that is section 11, void marriage. Now the next one is section 12, voidable marriage. Now this is again important section. There is difference between void and voidable marriage. The marriage which is void one, that means from the beginning it is void, from the that is, we can call it as ipso jure, it is void. Void ab initio, from the beginning, from the inception, it is void. And voidable means it is voidable at the option of either of party. That means initially it is valid one, but later on if one party raises any objection as per section 12, then it can be annulled by decree of annulment of marriage, and that comes under section 12. Now section 12, decree of nullity is necessary in respect to section 12, but whereas decree of nullity is not necessary in respect to section 11 of Hindu Marriage Act. That is one of the main difference between 11 and 12. Decree of nullity is necessary in respect to section 11 of Hindu Marriage Act, whereas decree of nullity is necessary in respect to section 12. Why? Because in under section 12 the marriage, firstly the marriage is valid one, and thereafter by decree of annulment of marriage we can annul it on one of these grounds. But in section 11 from the beginning it is void, therefore decree of annulment or nullity of marriage is not necessary in respect to section 11. Now section 12, that is voidable marriage. Now section 12 speaks about 4 conditions. First, that is non-consummation of marriage owing to the impotency of the respondent. Non-consummation of marriage owing to the impotency of the respondent. Now listen carefully, this impotency is a ground for voidable marriage under Hindu Marriage Act, whereas impotency is a ground for void marriage under Special Marriage Act. So Special Marriage Act, as per section 24 of Special Marriage Act, marriages are void one, and one of the ground for voidability of void marriage is impotency of the respondent under Special Marriage Act, whereas under Hindu Marriage Act impotency is a ground for voidability of marriage. So on this ground marriage becomes voidable, but on the ground of impotency of the respondent marriage becomes void as per Special Marriage Act, as per section 24 of Special Marriage Act. Now section 12, that is voidable marriage. First again I am repeating, non-consummation of marriage owing to the impotency of the respondent. So if respondent is impotent and marriage has not been consummated, this is one of the ground to take a decree for annulment of marriage under section 12 of Hindu Marriage Act. Now impotency may be physical or mental. It must be permanent and incurable. That is again important. If it is temporary in nature, then this section is not applicable. It must be permanent and incurable in nature. And petitioner's own infirmity is not a ground. It should be in respect to respondent's impotency. If petitioner is himself infirm or himself important or herself important, then at that time this clause, this section has no any application. This section is applicable when the respondent is important, and due to impotency of the respondent, marriage of the petitioner and respondent has not been consummated. Then petitioner can file petition on this ground. That is non-consummation of marriage owing to the impotency of the respondent. Now, or second, contravention of condition of clause 2 of section 5, which I had earlier discussed. That is, if unsoundness of mind, if 5 clause 2 speaks about what? If any person, if either of party is incapable of giving his or her consent due to his or her unsoundness of mind, then that marriage is voidable. That marriage voidable as per 12(1)(b) of Hindu Marriage Act. So this speaks about premarital unsoundness of mind. For postmarital unsoundness of mind, section 13 is applicable, and for premarital unsoundness of mind, section 12 is applicable. Section 12(1) clause B of Hindu Marriage Act. Now the next is, that is, consent of the petitioner was obtained by force or fraud as to the nature of the ceremony or as to any material fact or circumstances concerning the respondent. That means if petitioner's consent has been obtained at the time of marriage, if petitioner's consent has been obtained by force or fraud, As to what? As to nature of ceremony, or as to any material fact or circumstances concerning the respondent. Then at that time, the petitioner can file petition under section 12 of Hindu Marriage Act. But for that reason, there are some criteria, and that has been provided in section 12(1)(c), that petition must be presented within 1 year after force has ceased or after discovery of fraud. Once the force has been seized or once the fraud has been discovered, immediately petitioner has to file petition under section 12. That is, within 1 year, he has to file a petition under section 12. And secondly, that is, must not live with the respondent after force has ceased or fraud has discovered. That means he should not live with the respondent even after discovery of fraud or even after cessation of force. So both conditions should be fulfilled at the time of filing of petition under section 12 subsection 1 clause C of Hindu Marriage Act. That is, consent of the petitioner was obtained by force or fraud as to the nature of the ceremony or as to any material fact or circumstance concerning the respondent. So for this condition, both conditions are applicable. For this condition, that is, if the consent of the petitioner obtained by force or fraud and he has to file petition, then he has to file petition within 1 year after discovery of fraud or after force has been seized. And he must not live with the respondent after discovery of fraud and after force has been seized. So that is criteria. Thereafter, the next fourth condition, that is pregnancy of the respondent by some other person other than petitioner. Again, important, pregnancy of respondent by some other person other than petitioner. If petitioner wants to file petition on this ground that his wife is pregnant at the time of the marriage by some other person other than petitioner himself, then again he has to fulfill some criteria. That is, first, he must be ignorant of the fact at the time of marriage. At the time of marriage, he must be ignorant of the fact. Second, that petition must be filed within 1 year of marriage. And third, marital intercourse should not take place after discovery of the fact. So these three conditions should be fulfilled if petitioner wants to file petition on the ground of pregnancy of the respondent. First condition is what? He must be ignorant of the pregnancy of his wife at the time of marriage. If he was aware, then he cannot take defense of this ground or he cannot file petition on this ground. So he must be ignorant of the fact of the pregnancy of his wife at the time of marriage. Thereafter, that petition must be filed within 1 year of the marriage. So after solemnization of marriage within 1 year, he must have filed the petition. That is second criteria. And third, marital intercourse should not take place after discovery of fact of pregnancy of the wife. So if he discovered the fact of pregnancy of wife and thereafter marital intercourse takes place between him and his wife, then this ground is not applicable for him. So these are another three conditions which are applicable for section 12D, that is pregnancy of the respondent by some other person other than the petitioner. Now we'll be moving on next section, which one important section, that is section 13, divorce. Section 13, divorce. Everyone knows the difference between judicial separation and divorce. Judicial separation puts an end to a marriage, does not put an end to a marriage, whereas divorce puts an end to a marriage. So divorce, the grounds for judicial separation and divorce are same. So I'll be taking merely section 13, that is divorce. Now, after solemnization of marriage, the word starts the section starts with the word after solemnization of marriage. So for before solemnization of marriage, what happened between the parties doesn't matter. Here, important thing is what? After solemnization of marriage. So section 13 is applicable if these grounds are fulfilled after solemnization of marriage. So after solemnization of marriage, the first thing is what? That is adultery. Now, first ground is adultery. The word adultery has not specifically used in the act. What is exactly used in the act? That is not having sexual intercourse with a person other than spouse. Having physical relationship or sexual intercourse with a person other than spouse, on this ground that marriage is or that person can take divorce. Suppose his or her spouse is having some physical relation, then that person can take divorce on this ground. Now, adultery, for proving of adultery, strict proof is not necessary. For proving of adultery, circumstantial evidence is sufficient. For proving of adultery, single act of adultery is also constitutes single act of adultery is also ground for divorce. So adultery, that is the first criteria. Second criteria is cruelty. Cruelty, mental as well as physical cruelty. Again, specifically it has written that is cruelty, this word that is has after solemnization of marriage treated the petitioner with cruelty. That means after solemnization of marriage, if respondent treats the petitioner with cruelty, then petitioner can file petition on this ground for taking divorce. Now, cruelty may be mental, cruelty may be physical. So there are number of cases upon this fact, cruelty. Thereafter, next, that is important, desertion. Desertion period of 2 years is important. Basically, desertion includes two things: factum of separation as well as animus deserendi. Now, factum of separation means fact of separation. That is, both the persons have been separated. This is a fact. And animus deserendi means there is intention to separate. If spouses are living separate for job purpose, then this does not come under this condition, or they cannot take divorce on this condition. Why? Because they are living separate because of some reason. There is no intention to live apart. So animus deserendi, that means there must be a permanent intention to live separate or to reside separate from each other. So desertion includes two things: factum of separation and animus deserendi. Again, if a petitioner wants to file a petition on the ground of desertion, he has to fulfill the criteria that has been laid down in section 13. That is, petition must be filed after 2 years from the date of separation. So, date of separation and presentation of petition, there must be 2 years gap or 2 years period. Then only he can file petition on this ground, on the ground of desertion. So these two things are important. That is factum of separation, that is fact that both the parties have been living separately from each other. And second thing is animus deserendi, that is there is intention to reside separate. Both the parties are having intention to reside separate from each other. They are having permanent intention to reside separate from each other. Then only desertion is applicable. Now, the next point is conversion. Thereafter, unsoundness of mind. As I had discussed earlier, that is unsoundness of mind. This thing includes post-marital unsoundness of mind. If it is premarital unsoundness of mind, petitioner can file petition under section 12 of Hindu Marriage Act for annulment of marriage for the reason of premarital unsoundness of mind. But if it is post-marital unsoundness of mind, then he has a one remedy, that is he can take divorce on this ground, that is his or her spouse is unsound or is incapable of giving its consent due to unsoundness of mind. Next is venereal disease. Everyone knows about this. Thereafter, renounce the world. If either of party renounce after solemnization of marriage, if either of party renounce the world, then obviously this on this ground divorce can take place. Thereafter, not being heard of as alive for 7 years. Not being heard of as alive for 7 years. So if either of party not being heard of 7 years, has not been heard of 7 years, then on this ground that petitioner can take divorce. Now suppose both the parties, suppose petitioner without taking divorce, married for the second time or perform second marriage without taking divorce. On this ground, if petitioner married or has performed second marriage, then that second marriage is void. That second marriage is not valid. That second marriage is void. Why? Because even the party has not been heard of 7 years, merely this thing is not sufficient for performing second marriage. You have to take a divorce on this ground that that person responded not being heard of 7 years for 7 years. So you have to take a divorce on this ground, and thereafter you can perform second marriage. But without taking divorce on this ground, if you perform the second marriage, then that second marriage is absolutely void. So this criteria should must be fulfilled. And again, there is one presumption under Indian Evidence Act. Section 108 of Indian Evidence Act speaks about presumption of this not being heard of 7 years. So if any person not being heard of 7 years, and if other person is saying that that person is alive, now burden of proof lies on other person to prove that the person is alive. So if I am saying that XYZ is not being heard of as alive for 7 years, and other person is saying no, he's alive for 7 years, the presumption is what? He is presumed to be dead. He's presumed to be dead, not being heard of as alive. That means he's presumed to be dead. Now the burden of proof lies on other party who is saying that that person is alive for alive. So this presumption is applicable. Section 11108 of Indian Evidence Act, not being heard of as alive for 7 years. Now all these grounds, all these 7 grounds are based on, or these are based on fault theory. Now the next theory that came into existence in 1964 by Marriage Law Amendment Act 1964, and that theory is called as breakdown theory. So breakdown theory, and this 1A, this clause has been added in 1964 by Marriage Law Amendment Act 1964, and this is called breakdown. All above clauses, 7 तक के सारे clauses जो भी है, those are based on fault theory, whereas these clauses 1A, these clauses are based on breakdown theory. Now, and breakdown theory came into existence in 1964, Marriage Laws Amendment Act 1964. Initially, the period that has been laid down was 2 years. Later on, Marriage Law Amendment Act 1976, that period has been changed, and now it has been reduced from 2 years to 1 year. So after passing decree of judicial separation, once the decree of judicial separation has been passed and there is no resumption of cohabitation for 1 year or more year between the years between the parties, then on this ground either of party can take divorce. So after passing decree of judicial separation का decree pass हो गया, and now there is no resumption of cohabitation for 1 year or more between the parties. Still they are residing separate. So for 1 year, since 1 year and or more they are residing separate, now they can take divorce. Either of them can take divorce on this ground that even after passing of judicial separation decree, there is no resumption of cohabitation for 1 year or more. Earlier, by Marriage Law Amendment Act 1964, the period that was mentioned 2 years, but now after Marriage Laws Amendment Act 1976, that period 2 years has been curtailed down to 1 year. So now it is 1 year period. And the second ground is after passing decree of restitution of conjugal right, no resumption of cohabitation for 2 years or more. So even the decree of restitution of conjugal right has been passed, but still there is no resumption of cohabitation for 2 years or more. Then at that time, either of party can take divorce on this ground. So this is a ground for taking divorce. So this is based on breakdown theory, and this clauses have been added by Marriage Laws Amendment Act 1964, and the period has been changed or curtailed down from 2 years to 1 year by Marriage Laws Amendment Act 1976. Now the next, that is grounds for wife, added by again Marriage Law Amendment Act 1976. से ये grounds added हुए. These grounds are available only for wife. So the first ground is bigamy or rape, sodomy or bestiality. Or third, maintenance order under section 18 of Hama or under section 125 CRPC passed against husband, and still there is no cohabitation for 1 year or more, then on this ground wife can take divorce. So that means if maintenance order has been passed under section 18 or 125 against the husband, and still both are residing separate, or still there is no resumption of cohabitation between the parties, then wife can take divorce on this ground. And the next clause, that is marriage, if marriage that wife's that marriage of woman has been solemnized before 15 years of her age, now she can repudiate her marriage after 15 years but before attaining 18 years. So that we can call it as repudiation of marriage. She can repudiate her marriage once she has attained 15 years but before attaining age of 18 years. Now section 13 of Hindu Marriage Act deals with divorce, whereas section 27 of Special Marriage Act deals with divorce. Now we'll be moving on next section, that is section 13A, alternate relief. Again important from the point of pre-exam. Alternate relief. Now if any person has filed a petition for dissolution of marriage, now court can pass a decree instead of divorce. Court can pass a decree of judicial separation, that is called alternate relief. So in any petition for dissolution of marriage by a decree of divorce, court may pass decree instead of divorce. Court may pass decree of judicial separation. So there is mistake, decree of judicial separation, not judicial proceeding, it is judicial separation. So court may pass decree of judicial separation. Now except there are exceptions which has been provided by this section. Exception on the ground of conversion, renunciation of will, and presumption of death. So if any petition of divorce has been filed on the ground of either conversion or renunciation of will or presumption of death, then court may not pass a decree of judicial separation instead of decree of divorce. this ground is applicable only for other, this section is applicable only for other grounds except ground of conversion, renunciation of world, and presumption of death. At the same time, section 27A of Special Marriage Act deal with alternate relief. Here only in section Special Marriage Act, only presumption of death is an exception. Whereas on other ground, court may pass decree of judicial separation instead of decree of divorce. But only presumption of death is an exception under Special Marriage Act, whereas conversion, renunciation of world, and presumption of death, these three are exceptions for under Hindu Marriage Act. So this is another thing which is important from the exam point of view. Thereafter, next section, that is section 13B. I think everyone knows about this section very well. Divorce by mutual consent. Amardeep Singh versus Harvinder Kaur 2017 case, everyone knows about it. Where we can actually waive off the period of 6 months. Section 13B, divorce by mutual consent under Hindu Marriage Act, whereas section 28 of Special Marriage Act speaks about divorce by mutual consent. Now, three things are important. That is, parties have been living separate for a period of 1 year or more. When this petition is filed, first thing, those persons, both the parties should have living separate for a period of 1 year or more. Then only this petition can be filed. Thereafter, that they have not been able to live together. What they have to prove? That they cannot live together. So this is another thing. And third thing, what they have mutually agreed that their marriage should be dissolved. So if these three things are fulfilled, then the decree of divorce by mutual consent can be granted under section 13B. So section 13B, for application of section 13B, these three conditions should be fulfilled. That is, parties have been living separate for a period of 1 year or more, that they have not been able to live together, and third, that they have mutually agreed that their marriage should be dissolved. Now, this petition, the second clause of 13B speaks about that this petition must be not earlier than 6 months and not later than 18 months. So this 6 months period can be waived by Amardeep Singh versus Harvinder Kaur 2017 case, where it has been specifically some guidelines has been given by Honorable Supreme Court. That is, when the period of 6 months can be waived off, or when the period of 6 months can be cooled. Now, we'll be moving on next section, that is section 14. 14 deals with no petition for divorce to be presented within 1 year of marriage. So obviously, after solemnization of marriage, within 1 year after solemnization of marriage, no petition for divorce can be presented. But in case of exceptional hardship or depravity, it can be filed. So, but we'll have to prove those things, that these are the cases comes under exceptional hardship and depravity. So on that ground, section 14 can be we can file petition within 1 year of marriage. But otherwise, no petition for divorce to be presented within 1 year of marriage. So section 14 deals of Hindu Marriage Act deals with this, whereas section 29 of Special Marriage Act deals the same. Now we'll be moving on next section, that is section 15, divorced person when marry again. Now, when divorced person marry again, that is important. There is no right of appeal against the decree. Then obviously divorced person may marry again. But if there is right of appeal, then the time for appeal expired or the appeal has been dismissed, then in that case, divorce can. So, section 15 speaks about divorced person. Am I audible?
Yes, madam.
Okay. Section 15, divorced person when marry again. If there is no right of appeal against the decree, then divorced person can immediately perform second marriage. Thereafter, next, if there is right of appeal, but the time of appeal has been expired or the appeal has been dismissed, then immediately that person can marry for the second time. So section 15 of Hindu Marriage Act speaks about this, whereas section 30 of Special Marriage Act deals the same. Now the next, we'll be moving on next section, that is section 16, legitimacy of children of void and voidable marriage. I'm repeating this, that children born out of void and voidable marriages are legitimate, but they are only entitled to their parents' property. They are able to inherit the interest of their parents in ancestral property. But it has been provided in section 16, they are legitimate. They are having legitimate status, but they are entitled to their parents' property only, or if their parents are inheriting any interest in ancestral property, then they are entitled or they are able to inherit those interests also. At the same time, along with this section, we'll have to read the another section, that is section 112 of Indian Evidence Act, that is presumption as to legitimacy of children. So we'll have to read that section also along with this section. So that is, you have to read both the sections together. The next is section 19. It is important while filing of petition. Quote to which petition shall be presented. Now, CPC, Civil Procedure Code, speaks about jurisdiction, territorial jurisdiction, pecuniary jurisdiction, subject matter jurisdiction. And Hindu Marriage Act also speaks about jurisdiction. So, both the things speaks about jurisdiction. Territorial jurisdiction under section 15, 16, 17, 18, 19, 20, 21 speaks of CPC speaks about territorial, pecuniary, subject matter wide jurisdiction. And section 19 of Hindu Marriage Act speaks about jurisdiction of Hindu Marriage Act, that is filing of petition under Hindu Marriage Act. So which section is applicable? Where there is dispute between general law and special law, normally special enactment will prevail. Always special enactment, special statute will prevail. So that thing should keep in your mind. That is, if there is dispute between general law, CPC is a general law, whereas Hindu Marriage Act is a specific enactment. So which enactment will prevail? Specific enactment. So for applicability of territorial jurisdiction, section 19 is applicable. So section 19 speaks about what? Court to which petition shall be presented. The first criteria is the marriage was solemnized. Every clauses, there is one word which has been used, that is or. Whenever or is used, that means it is, that section is, or means what? Either of. Either of. So it is disjunctive in nature, not conjunctive in nature. So where the marriage has been solemnized, or where the respondent resides, or where the parties lastly resided together, or in case a wife is the petitioner, where she resides. That is important. So these four are main conditions for filing of petition. Territorial jurisdiction, we can say the marriage where the marriage has been solemnized. So if marriage is solemnized at Pune, if respondent resides at Nashik, if parties were lastly resided together at Mumbai, then which court has jurisdiction? Either of them. Any court, Pune court, Nashik court, Mumbai court, any of them has a jurisdiction. But if a wife is residing at Thane, then if the wife is petitioner, then Thane court is having a jurisdiction to deal with the petition. So where the marriage, now This is or either or criteria. But we'll have to read this section combined, that where the marriage has been solemnized, or where respondent resides, or where the parties lastly resided together, or in case of wife is the petitioner, where she resides. So this is jurisdiction clause, conditions for the filing of petition, and that comes under section 19 of Hindu Marriage Act. Now section 31 of Special Marriage Act deals the same. So section 19 of Hindu Marriage Act deals the same, whereas section 31 of Special Marriage Act deals the same. Now the next section, that is section 20, that is contents and verification of the petition. This is another important point from exam point of view. Every petition shall state that there is no collusion between the parties. This is important part. Every petition must show that there is no collusion between the parties, and that has been given under section 20, except in a petition under section 11. Section 11 की petition कौन से है? Void marriage. So in case of petition for annulment of marriage under section 11, this section has no applicability. This section does not apply. That means every petition shall state that there is no collusion between the parties, but if petition is filed under section 11 of Hindu Marriage Act, then this section has no any applicability. Now, thereafter, section 32 of Special Marriage Act speaks about the same, but no any exception has been provided under section Special Marriage Act, under section 32 of Special Marriage Act. So only exception has been provided under Hindu Marriage Act, whereas under Special Marriage Act, no any exception has been provided. Under Special Marriage Act, it is specifically mentioned that every petition shall state that there should not be collusion. There is no collusion between the parties. So every petition should state that there is no collusion between the parties under Special Marriage Act also, and there is no exception under Special Marriage Act. Whereas section 11 is an exception under section 20 of Hindu Marriage Act. Now I'll be moving next section, that is section 21. Now, I'll be discussing merely main points of section 21. Section 21B. Every trial shall be concluded within 6 months from the date of service of notice on the respondent. So that means it is mandatory period that has been given by the act, by the statute itself. That is, every trial must be concluded, shall be concluded within 6 months from the date of service of notice on the respondent. And thereafter, every appeal shall be concluded within 3 months from the date of service of notice of appeal on the respondent. So trial shall be concluded within 6 months from the date of service of notice, and every appeal shall be concluded within 3 months from the date of service of notice of appeal on the respondent. So that is important part. Thereafter, next section, section 21C, that is, no document shall be inadmissible in evidence on the ground that it is not duly stamped or registered. So documents are, if the document is not duly stamped or registered, then it is inadmissible in evidence. So it is not so in Hindu Marriage Act. No document shall be inadmissible. कोई भी document inadmissible नहीं हो सकता on the ground that that document is not duly stamped or not duly registered. So that has been added by Marriage Law Amendment Act 1976. So stamping and registration, duly stamped and duly registered document is not necessary for admissibility of document under Hindu Marriage Act. So 21C. Thereafter, next, that is section 22, in camera proceeding. Every proceeding shall be conducted in camera and shall not be lawful to print or publish. So it is not lawful, or it is not permissible to print or publish the proceeding, except Supreme Court and High Court judgments. So judgment of High Court and judgment of Supreme Court can be printed or published, but with the previous permission of the court. If any person contravenes the provision, then it is liable for fine of rupees 1000. And that is, this same section is applicable in, say, Special Marriage Act also. Only section 33 is there. 33 of Special Marriage Act is the same fine is there, 1000 rupees. So every proceeding shall be conducted in camera, and it shall not be lawful to print or publish except judgment of High Court or Supreme Court with the previous permission of the court. Otherwise, it is liable for penalty, it is liable for punishment, fine, and that is rupees 1000. Now, the next important section, that is section 23, decree in proceeding. We can call it as bar of matrimonial proceedings. Now, this section starts with the word in any proceeding under this act. So, this section is applicable for any proceeding under this act. Maybe the proceeding of restitution, judicial separation, divorce, void marriage, voidable marriage, in any proceeding under this act, whether defended or not. So, whether defended or not means what? Even in ex parte proceeding also this section is applicable. So whether defended or not, if the court is satisfied that. The word court is satisfied that speaks about it is a duty of court to satisfy or to look into the matter whether section 23 has been fulfilled or not. So it is a duty of court. It imposes duty on court. That is whether section 23 has been completed or fulfilled or not, whether there is any bar under section 23 for granting any relief under Hindu marriage or not. So the section start with word in any proceeding under this act. That means this section is applicable for every proceeding under this act, whether defended or not. That means whether it is ex parte proceeding or whether it is contested proceeding. If the court is satisfied, that means it is duty of court. Now, what is the duty of court? Now, next, any of the ground for granting relief exists, and the petitioner, except in case where the relief is sought by him on the ground specified in subclause A, B, or C of section 5, is not in any way taking advantage of his or her wrong or disability. The person who is seeking or claiming equity must come with clean hand. So this is a principle of equity, that petitioner should not take advantage of his own wrong or her own wrong or disability. So first thing is what? If petitioner himself is at fault, if petitioner is taking advantage of his or her own wrong or disability, then at that time this matrimony, that means at that time it is a duty of court to see that whether petitioner is taking advantage of his or her wrong or not. If petitioner is taking advantage of his or her own wrong, then matrimonial relief, there is a bar to grant matrimonial relief. If petitioner is taking divorce, if petitioner has filed a petition for taking divorce and he himself is at fault, then court cannot grant him a relief. Court cannot pass decree of divorce on this ground. Why? Because he is taking advantage of his or her own wrong. But there is some exception that has been provided, that is subclause A, B, or C of section 5. So except in a case where the relief is sought by him on the ground specified in subclause A, B, or C of section 5. So these clauses are the exception for applicability of this section. Now the next, that is where the ground of the petition is the ground specified in clause 1 of subsection 1 of section 13. The petitioner has not in any manner been accessory to or connived at or condoned the act or acts complained of, or where the ground of the petition is cruelty, the petitioner has not in any manner condoned the cruelty. If the ground is adultery, then that petitioner, if petitioner has condoned the adultery, उसने माफ किया adultery को, respondent ने जो भी किया उसने उसको माफ किया, once he condoned the act, he cannot take relief on this ground. Or if he has connived it, himself involved in that, if he himself insists the wife to do that act, then at that time he cannot take divorce on this ground. So first part, that is has not accessory to, connived or condoned, is applicable for adultery, whereas second part, that is condoned cruelty, is applicable merely for the cruelty. So once the cruelty has been condoned by the petitioner, he cannot take divorce on the ground of cruelty. Why? Because that cruelty has been condoned by him. So once he condoned it, now condoned means what? Condoned means he condoned it and again they have started or they have resumed cohabitation. That is important. Merely condonation, maaf kiya, is not sufficient. Merely condonation is not sufficient. What is important? Condoned as well as they have resumed the cohabitation. So maaf kiya, जैसे कंसेंट टर्म्स बनाए जाते हैं, है ना? सो कंसेंट टर्म्स होते हैं, कंसेंट टर्म्स में कंडोन किया, उसने माफ किया, एंड नाउ बोथ आर रेडी. वन सेक, मैडम, कैन यू गिव मी वन मिनट?
Yes, yes, sure, madam.
1 minute, huh? Hello?
Yes, ma'am.
Okay, so where the second ground is applicable, firstly, first ground, second clause B, that is, if petition is filed on the ground of cruelty, sorry, if the petition is filed on the ground of adultery and that adultery has been condoned by the petitioner, if it is accessory to or connived by the petitioner, then petitioner, this is a bar to grant relief on this ground. Second is what? Cruelty. If petition is filed on the ground of cruelty and if petitioner has condoned the cruelty, that means they have prepared consent terms, he has condoned the respondent and he has pardoned the respondent, and thereafter they both have resumed cohabitation, then thereafter he cannot filed a petition on the ground of cruelty. Why? Because he has condoned the cruelty. Thereafter next is, that is, when a divorce is sought on the ground of mutual consent, such consent has not been obtained by force, fraud, or undue influence. This is another bar, that is, if divorce by mutual consent, in case of divorce by mutual consent, if the consent has been obtained by force, fraud, or undue influence, obviously divorce by mutual consent cannot be granted. The decree of divorce by mutual consent cannot be granted. Thereafter next, so this is a bar for divorce by mutual consent. Thereafter next, the petition is not presented or prosecuted in collusion with the respondent. We have earlier discussed also, that is, there should not be collusion. We have discussed this point. There should not be collusion between the parties, but exception is section 11. Section 11 is an exception where अभी हमने देखा था सेक्शन 20 में देखा था, वेरिफिकेशन में देखा था, वेरिफिकेशन ऑफ पिटिशन में देखा था, दैट इज the parties, but in case of petition filed under section 11, then that is an exception for petition under section 11. So this is same clause. The petition not being a petition presented under section 11 is not presented or prosecuted in collusion with the respondent. So apart from section 11, for all other sections, for all other matrimonial relief, this clause is applicable. There should not be collusion between the parties. If there is collusion between the parties, relief cannot be granted. Thereafter, next, there has not been any unnecessary or improper delay. That is again important. If parties are residing separate since 10 to 12 years, and now petitioner has filed a petition for restitution of conjugal right after 12 years, he has filed a petition. So, as per this clause, it is a bar. Now, there has not been any unnecessary or improper delay in the institution of the petition. So, if that petition is filed after 12 to 13 years, there is improper or unnecessary delay. He has to explain that delay, that why he has filed the petition after 12 years. So this is again a bar for filing of or for granting of relief. And the next is, there is no other legal ground why relief should not be granted. Then, and in such a case, but not otherwise, the court shall decree such relief accordingly. There is no other legal ground why relief should not be granted. Then, and in such a case, but not otherwise, the court shall decree such relief accordingly. Now, section 12 में हमने देखा था, section 12 में हमने देखा कि for pregnancy of the respondent, if respondent is pregnant by some other person other than the petitioner, petitioner can file petition under section 12, but he has to file a petition within 1 year. There are some other conditions also, so those conditions should also be fulfilled, and if it is not fulfilled, then there is bar for granting of relief, and that has been provided in section 23 of Hindu Marriage Act, which is very, very much important section. Now, next, before proceeding to grant any relief, it shall be the duty of the court in the first instance. बहुत सारे लोग आते हैं और बोलते हैं कि why counseling is necessary? There is no chances of reconciliation between the parties. Even lawyers भी आके यही बोलते हैं कि there is no chances of reconciliation between the parties, but section 23 of the act cast or imposes duty on the court. If it is a duty on court, if it is a duty of the court, obviously it is a duty of lawyers, it is a duty of litigants also to make every endeavor to bring about reconciliation between the parties. And for this reason, we usually refer the matter for counseling. So, it is a duty of court in the first instance to make an endeavor to bring about reconciliation between the parties. Now, provided that, this is another important part from exam point of view, that is, these clauses are the exception. That means if any petition of divorce has been filed on the ground of these clauses, that is 2, 3, 4, 5, 6, 7, venereal disease, conversion, not being heard of 7 years, all these clauses, then at that time, reconciliation, it is not a duty of court to make an endeavor to bring about reconciliation. So provided that nothing contained in this section, now the proviso clause has been provided. Provided that nothing contained in this subsection shall apply to any proceeding wherein relief is sought on any of the grounds specified in clauses 2, 3, 4, 5, 6, or clause 7 of subsection 1 of section 13. So these are exception for condition laid down in subsection 2 of section 23 of Hindu Marriage Act. And now the next part is that the court may, if the parties so desire, or if the court thinks it just and proper so to do, adjourn the proceeding for a reasonable period not exceeding 15 days and refer the matter for reconciliation. Now, once the counseling has been done, and again, while conducting cross examination, or again when the matter proceeded further, if court thinks that there are chances of dispute, there are chances of reconciliation, then court can refer that matter again for the reconciliation, but for a reasonable period not exceeding 15 days. Now, here the word may is used. Whenever word may is used, it is not obligatory, it is directory provision, it is discretionary provision, it is discretion of the court. Whenever the word shall is used, it is obligation, it is mandatory provision. So that is important thing. Here the word may is used, that means it is not mandatory, it is discretion of court to refer the matter or to adjourn the proceeding for reconciliation purpose, but not exceeding 15 days. So it is discretion of the court. Now the next part, that is section 24, maintenance pendant light. Everyone knows about this section. Maintenance pendant light, that is maintenance during proceeding. Section 24, section 25, permanent alimony and maintenance. Now section 24 is what maintenance pendant light, that is that we can usually call it as interim maintenance. Maintenance pendant light, that means maintenance during the proceeding. Now, under section 24 of Hindu Marriage Act, either wife or husband who has no any independent income can file a proceeding under section 24, can file an application under section 24, that is for interim maintenance. So section 24 is applicable for wife as well as husband who has no any independent income. Now, here in section 24, there is no any rider, no any restriction, no any conditions provided by section 24. Merely the condition is what? That applicant must be unable to maintain himself or herself, and non-applicant should have sufficient means. These two conditions must be satisfied while granting maintenance under section 24. So even though it is void marriage petition, even though it is section 12 petition, even though it is petition for divorce or restitution of conjugal right, section 24 applicable. Wife can also claim maintenance, husband can also claim maintenance, but this is not so in case of Special Marriage Act. In Special Marriage Act, merely wife can claim interim maintenance, not husband. So this is main difference between Hindu Marriage Act as well as Special Marriage Act. Section 24 Hindu Marriage Act, where wife as well as husband both can claim interim maintenance, but under section 36 of Special Marriage Act, only wife can claim interim maintenance. That is section 24, and this section 24 application shall be disposed of within 60 days. So it is mandatory criteria. It has to be disposed of within 60 days. Now thereafter next section 25, that is permanent alimony. So at the time of passing of decree or afterwards, subsequent to decree, party can file application under section 25 for claiming permanent alimony. But decree is essential. If divorce has been dismissed, if divorce petition has been dismissed, then permanent alimony cannot be granted. If it is decreed, then only permanent alimony can be granted. So that is important. Decree is essential. That petition must be decreed. That is important part under section 25. Either wife or husband can file petition under section 25 permanent alimony. Thereafter, next, that is section 26, custody of children. Usually, in matrimonial cases, wife or applicant file a interim maintenance application for herself or for child also, or for her son or daughter also. Now that comes under section 26. Custody, maintenance, education, for education, they can file an petition or application under section 26 of Hindu Marriage Act. And that application should also be disposed of within 60 days. So again, 60 days is obligation or obligatory criteria laid down in section 24 and 26 of Hindu Marriage Act. Now, next essential section, that is section 27, which deals with disposal of property. Now, disposal of property means what? Basically, section 7 of Family Code Act. Everyone have, I think, have gone through the section 7 of Family Code Act. Section 7 of Family Code Act deals with the powers and jurisdiction of family court. One of the power is family court can deal with the matrimonial property, suits in respect of matrimonial properties. Again, section 27 deals the same. Section 27 speaks about what? In any proceeding under this act, the court may make such a provision with respect to any property. I'm repeating this word, presented at or about the time of marriage. Presented at or about the time of marriage. So any property which is presented at or about the time of marriage, which may belong jointly to both the husband and wife. Jointly भी own किया है उन्होंने, but it should be presented at or about the time of marriage. Then only section 27 is applicable. Then only court may pass decree in respect to those property, in respect to that property. So property presented at or about the time of marriage, which may belong jointly to both the husband and the wife. That property covers under section 27 of Hindu Marriage Act, and for dealing the suits in respect to section 27, family court has a jurisdiction, and that is given under section 7 as well as section 27. 7 of Family Court Act and 27 of Hindu Marriage Act. And now the last and important section of Hindu Marriage Act from the exam point of view, that is section 28, appeal. So every appeal from the family court shall be preferred within a period of 90 days from the date of decree or order. So for decree and order, the period is 90 days. So 90 days is a period. So every appeal under this section shall be preferred within a period of 90 days from the date of decree or order. So here, these are main provisions of Hindu Marriage Act. Just go through your paper also, previous papers also, and जब आप पढ़ाई करते हो ना, while doing study, you have to read one section along with another section also. If that section has any connection with other section, read it immediately. Otherwise वो दिमाग से निकल जाएगा. So आपको वो दोनों चीजें साथ में रीड करना है. जैसे मैंने आपको अभी ज्यादा से ज्यादा मैंने ट्राई किया है. I tried to cover all the things. कुछ रह गया होगा तो आप पढ़ते पढ़ते आपको समझ में आ जाएगा वो सारी चीजें. लेकिन ये सारी चीजें आपको कवर अप, जब एक सेक्शन पढ़ते हो दूसरा भी पढ़ो उसके साथ में. व्हाट इज द डिफरेंस बिटवीन स्पेशल मैरिज एक्ट एंड हिंदू मैरिज एक्ट? रीड इट इमीडिएटली. read the sections. This section deals with restitution under Hindu Marriage Act. This section deals with restitution under Special Marriage Act. What is the difference between both sections? Read it. जैसे ये होता है, जैसे अलग एक्ट्स भी है तो वो भी एक्ट आपको पढ़ना है साथ में, तो टुगेदर रीडिंग इज इम्पोर्टेंट. हम हमेशा बोलते हैं कि स्टैट्यूट को एक साथ में पढ़ो if there is connection between both the statutes. So that's why I have used earlier one word, statute in pari materia, that is doctrine of pari materia. One statute, if it is connected to other statute, we'll have to read both the statutes together. Same it is applicable for the sections. If one section is there and if there is a connection between two sections, both the sections will have to read together, so that it will be more easier for us to understand the provision, to understand the statute. Now, I think time is over.
Hello.
Hello.
Thank you very
Yeah.
much, madam.
Thank you.
Thank you, Honorable Judge Srimati Netra Kank, madam, for explaining the provisions of Hindu Marriage Act in very lucid manner. I am very much sure that this is going to help all the participants in their upcoming exams. I am also thankful to Chairman and Vice Chairman, as well as other members of Bar Council of Maharashtra and Goa for organizing this online lecture series, and also thankful to Sharad sir for arranging this online platform. One more announcement for the participants. Tomorrow also we are having another lecture on one of the important topics. So please be with us sharp at 5:45 p.m. See you all. I request Sharad sir to
मॅडम
conclude the meeting.
मॅडम मॅडम
हाँ sir.
कोणाचे ते चॅट बॉक्स मध्ये क्वेश्चन आहेत तेवढे क्लिअर करून घ्या ना सर. क्वेश्चन्स होते बघा.
ओके ओके बघते ना सर.
हा मॅडम रिप्लाय देते.
Chat box is not visible, ma'am.
Yes sir, मला पण नाही दिसत आहे. मला पण दिसत नाहीये सर चॅट बॉक्स मध्ये काही.
एक मिनिट. बघा मॅडम आलेत क्वेश्चन्स आता बघा.
Factum valid, please explain madam factum valid.
Okay. Doctrine of factum valid. That means the meaning of doctrine of factum valid is, am I audible?
Yes madam.
The meaning of doctrine of factum valid is basically once the act accomplished or done, once the act accomplished or done, it cannot be altered by 100 text of law. That means how it is applicable in respect to section 7. Section 7 deals with ceremonies of marriage. So it speaks about saptapadi and invocation before sacred fire. So if these ceremonies are fulfilled, once this ceremonies takes place, no other, that means if it is fulfilled and if registration, जो section 8 में दिया है, registration for marriage is a mandatory criteria that has been given in Sima versus Ashwini Kumar case. But if registration not done, registration of marriage not done, but saptapadi takes place, then whether that marriage is void one, merely because due to the non-compliance of registration, whether that marriage is void one, obviously not. That is called doctrine of factum valid. यहाँ पे section 8, that is statute itself saying that it is mandatory, registration is mandatory, registration करना ही है. पर अगर सप्तपदी हुआ है तो रजिस्ट्रेशन नहीं हुआ फिर भी कोई असर नहीं पड़ता, फिर भी that marriage remains valid, marriage valid ही रहेगा. So that's why doctrine of factum valid is applicable. कोई भी कुछ भी हो जाए, कोई भी लॉ कुछ भी बोले, लेकिन अगर एक फैक्ट हुआ है, द फैक्ट्स अकम्प्लिश. What facts accomplish? Marriage takes place. How marriage takes place? As per Hindu rites and rituals. How? That has been given under section 7. 7 में दिया है सप्तपदी takes place, invocation before sacred fire takes place. So if that marriage takes place, act, that fact accomplished, act done. Now no any other thing can alter it. दैट मीन्स रजिस्ट्रेशन अगर नहीं किया फिर भी वो मैरिज इनवैलिड नहीं होगा, वो मैरिज वैलिड ही रहेगा एज पर हिंदू मैरिज एक्ट. वी आर सेइंग or we are dealing with respect to Hindu Marriage Act only. I am not speaking about Special Marriage Act right now. For Special Marriage Act registration is necessary. So doctrine of factum valid का यहाँ पे application कैसा है ये मुझे बताना था. And इसके ऊपर क्वेश्चन आ सकता है और क्वेश्चन पूछ सकते हैं, इसलिए मैंने आपको यहाँ पे समझाया व्हाट इज डॉक्ट्रिन ऑफ फैक्टम वैलिड. अंडरस्टैंड?
Yes, madam. One more question: whether execution proceedings are required to be filed? Is it necessary?
What is it? What is it?
Whether execution proceedings are required to be filed under section for applicable application of section 24.
Right now I cannot say anything on this point because I am here as a judge. So
Okay, madam, no issues.
so
One more question regarding can we file or when to file application for maintenance during the proceedings of mutual consent?
mutual consent.
Yes.
What is the question? During
When should we
proceedings of
file application for maintenance during
in
mutual
mutual
consent?
consent. In
Yes.
mutual consent. What is the meaning of mutual consent?
Mutual by the amicably mutually by both the parties.
Both the parties. That means they have agreed upon certain terms. They have
Correct.
agreed that something ये हुआ है, ये लेना है, ये हुआ है, ये सारी चीजें होने के बाद they filed mutual consent petition.
Correct.
Correct?
Correct.
So whether section 24 is applicable in that case? Because if it is filed, then it becomes contested petition, and mutual consent petition is not a contested petition.
Correct. Yes, madam. And one more request that kindly provide this PPT to us so that we can be able to share it with the participants. There are so many requests from the participants regarding this.
What PPT?
Regarding this PPT.
Okay, I'll
If
provide
it is
it.
possible,
Yes,
I'm
yes, I'll
requesting.
provide it. I'll provide it.
Thank you so much.
Okay.
Now I request.
Is there
anything,
anything left?
just give me a minute. I will just check it out.
Time management for giving pre-examination.
Only one question related here. Senior division law under section 26 minor custody अर्ज करता येईल का?
Right now I cannot say anything in this respect.
Okay, madam. Okay, no issue. I think all things
Only
are
in
covered.
respect to provisions I can say. और प्री का एग्जामिनेशन का तैयारी करना है आपको, प्री का टाइम मैनेजमेंट करना है. सो द थिंग इज दैट ज्यादा से ज्यादा लोग ना निगेटिव पॉइंट्स पे फोकस करते हैं. मुझे जो लगता है कि निगेटिव, ये निगेटिव आता है, ये निगेटिव है, निगेटिव आया तो मेरा इतने पॉइंट्स 0.50 चला जाएगा. बट इफ पॉजिटिव आ गया, इफ आंसर करेक्ट आ गया तो 2 पॉइंट्स मिलेगा, ये कोई नहीं सोचता है. Always we focus on negative points rather than positive points. So focus on positive things, positive points, not upon negative things. जो भी है, और जैसे आपको जो भी जब आप पेपर पढ़ना शुरू करते हो ना, तो स्टार्ट with careful, means carefulness is important thing. पहले आपको पूरा केयरफुली उसको पढ़ना है पेपर और फिर उसको सॉल्व आउट करने के लिए लेना है। तो निगेटिव पॉइंट्स पे फोकस मत करो, पहले पॉजिटिव पॉइंट्स पे फोकस करो। ये ध्यान में मत रखो मेरा 0.50 चला जाएगा, 0.50 करके इतना चला जाता है, वो बात की बात है। पहले आपको ये मिलने वाले, आपको ये मिलना है। और ये चीज हमेशा मैं सबको बोलती हूँ, ये चीज हमेशा ध्यान में रखो, एक भी सीट होगा ना वो मेरा होगा, ये ध्यान में रखो। ये एक पॉजिटिव एटीट्यूड अपने आप में लाओ कि एक भी सीट है तो दैट इज माइन एंड आई विल बी देयर। सो दैट्स ऑल। टाइम मैनेजमेंट जो भी है, आपको बहुत सारे प्रीवियस पेपर्स पढ़ने हैं, आपको फोकस करना है, आपको बेयर एक्ट्स पढ़ने हैं। पहले बेयर एक्ट्स कैसे पढ़ा जाता है उसको सीखो। बेयर एक्ट्स में हम ना इंटरप्रिटेशन ऑफ स्टैट्यूट हमने कभी पढ़ा नहीं होता है। सो इंटरप्रिटेशन ऑफ स्टैट्यूट को हम ध्यान नहीं देते उसको। जैसे हर बेयर एक्ट में इंटरनल एड होते हैं और एक्सटर्नल एड होते हैं। तो इंटरनल एड पे हमें ध्यान देना है। जैसे स्टार्ट विद द प्रीएम्बल, स्टार्ट विद शॉर्ट टाइटल ऑफ द एक्ट, स्टार्ट विद लॉन्ग टाइटल ऑफ द एक्ट, प्रीएम्बल, मार्जिनल नोट्स, एवरीथिंग, एक्सप्लेनेशन क्लॉज, इलस्ट्रेशन, प्रोविजो क्लॉज, सब बेयर एक्ट में है। और प्री के लिए सिर्फ बेयर एक्ट बहुत इंपॉर्टेंट है। मेंस के लिए आप कमेंट्स पढ़ो, कमेंट्रीज पढ़ो, लेकिन प्री के लिए सिर्फ बेयर एक्ट काफी रहेगा।
Okay, madam. I assure that I think all the participants will keep these instructions in mind while appearing for the examination. Thank you very much, madam. Thank you so much.
थैंक यू एंड बेस्ट ऑफ लक सबको।
Thank you so much.
ओके
Shara sir, may I request you to conclude the meeting?